You can be seated, thank you. Good morning, everyone.
Good morning, Judge.
All right, do we have some issues we need to talk about?
We do, Your Honor. If the court recalls last Friday, I had promised the court that I would give the court a case on the issue of provocation. I have given to the prosecution that case. It's Gibbs versus State. It's located at 789 Southern 2nd 443. It was decided in 2001. May I approach the... And I can argue it if the court would like me to.
State, have you had an opportunity to review this?
I have, and I believe Mr. Escobar is going to have to argue the case.
Okay. I need a chance to read it.
It's directly on point with our issue, Your Honor.
All right, I'll take a look at this and...
Your Honor, the state, I apologize for interrupting, but the state does have an argument regarding that, so I'm suggesting the court at some point before you make a ruling, I could suggest that you allow Mr. Escobar to argue his point, so that, and then I'll know specifically where he's coming from.
Okay.
I'm not sure if it's going to impact opening statement.
I think it will. It's an easy case to read, Your Honor. I think it's only 2 pages. But I will tell you, and I'll read you the holding or the reasoning of the court. It said in Gibbs, the court says, the court failed to make the jury aware that the word provoked, as used in the instruction, and this was the same type of instruction, a self-defense instruction, did not refer to mere words or conduct without force. In other words, provocation has to be force. Provocation cannot be words. And so I think that Mr. Martin has at least agreed that a jury instruction cannot be in this case because there is no evidence of provocation, period. Now he wants to go one step further and he wants to argue to the jury that somehow the exchange of verbal communication between my client and Mr. Oulson was somehow inappropriate. It has no relevance in this case because when you look at the jury instruction, provocation now is out the window. And so it is totally not relevant. It's a 403, huge 403 issue. And he should not be able to comment at all on whether it was appropriate or inappropriate for that verbal exchange to take place because this case is directly on point.
Your Honor, the case is Gibbs versus Florida, 789 Southern 2nd 443. It's a 4th District case decided in 2001. Your Honor, if you would go to the second page at the top, and for the case law side, it will be page 444. In that particular case, the defense counsel wanted the jury to understand that any provocation by appellant had to be by force or the threat of force. He was concerned that the jury might be confused and think that merely provoking someone by complaining they didn't say good morning justified the victim's attack on the appellant and did not justify appellant in defending herself against attack. If you go down where you see, it'd be starting on page 445, the court agreed that the jury instruction given by the trial court was inaccurate to properly charge the jury in this case. The instruction stated that the appellant could not defend herself with non-deadly force if she initially provoked the victim. That's what the jury instruction that was given. The court went on to reason and note, by not limiting provocation to the use of threat of force, the court failed to make the jury aware that the word provoked, as used in the instruction, did not refer to mere words or conduct without force. Stated another way, the instruction gave the court, the instruction given by the court eliminated the use of non-deadly force in self-defense if there was any provocation by the defendant, no matter how slight or subjective the provocation. By that standard, mere insult could be deemed sufficient to prohibit defendant oneself from another's attack. if you go down, the court reasoned that because the instruction did not limit provocation to some force or threat of force, the instruction could have misled the jury to believe that the appellant's pointedly asking the victim why she failed to acknowledge her greeting and/or appellant's racial retorts and obscene gestures were sufficient to provide sufficient provocation to preclude appellant from defending herself from attack by the victim. The court went on to say, yes, we know there's a standard instruction. The clarification that the defense sought here was particularly applicable to the facts of the case and should have been given. I went through that so the court could understand the analysis that the appellate court did. They acknowledged that the standard jury instruction deals with the issue of provocation. They also indicated that the standard jury instructions can be modified and made clear under specific circumstances, and that if there is in fact coupled with the instruction about provocation that it has to be force on force and mere words are not sufficient, then it's not misleading. So applying the facts of this particular case, in this particular case, after Mr. Reeves leaves the theater and complains to the manager and is coming back, the testimony will be that Mr. Oulson had discontinued using his phone. It was down. Mr. and Mrs. Oulson were sitting there and watching the movie. The testimony from the state witnesses will be that as Mr. Reeves returned, there was no looking, there was no commenting. It was over. It was Mr. Reeves, when he came back and he initiated contact, knowing that everything was done. Everything was done, and made comments to the fact, and I'm paraphrasing, words to the effect, okay? I see you put your phone away or something like that. But again, he has had the contact. That situation falls into the area of reinitiating, rekindling, if you will, and very, I'll use hostile, unfriendly, whatever, that was over and done with. And so there was in fact a rekindling. But those words in that situation would in fact, if the court modified the instruction, informing the court that mere words themselves are not sufficient provocation, then it's not misleading. The state has a right for the jury to know Mr. Reeves' state of mind as he was coming back. Why did he lean forward? We're going to see it. Witnesses are going to testify that it occurred. There's going to be an exchange. If that is disallowed, then there's no predicate leading up to the fact of the tossing of the popcorn and the shooting. There's none. It's just like, okay, he just stood up and did it. So we have to get into the fact there was a predicate, there was an exchange. And so I think it is relevant. It places the actions of both participants in proper context so that the jury can make an informed decision. So I'm suggesting to the court that we modify the jury instruction. We modify it to comport to this particular case law so that the jury has a clear understanding that after Mr. Reeves came in and sat down, it wasn't like sat down, seconds later, okay, Mr. Oulson just stands up and does what he does. See, that's just a vacuum. There's no context. The jury has to know there was a preceding event that triggered the actions of these two parties. Are we going to argue that this is sufficient provocation and reverse the standard that he can't do it? No, we're not going to do that. But we are suggesting to the court that these facts are in fact relevant, and with the modification, as indicated by the court, that you can do, that this is in fact relevant. Otherwise, we're just taking it out of context. So even if the court indicates or decides that, okay, we're just not going to do the jury instruction and I'm not going to modify it, the facts that I just recited to the court are relevant, just like I indicated that they are relevant. So we understand the limitation. We are not going to make the argument like that, the jury instruction is reversed. We are not going to do that, but we do have a right to lay all the facts in front of the jury.
Judge, let me first point out that that case was not hard to find. It was actually in the jury instruction. It was cited under that particular section of provocation. So it's a case, obviously, that even the Supreme Court has acknowledged needs to be considered. Now let's listen to what the prosecutor is saying. Well, we're not going to use the word provocation, but we're going to use rekindled, hostile, unfriendly. That is provocation. That's exactly what he wants to do. He wants to term provocation by some other word.
Those are words, Mr. Escobar. Those are just words. So words are not provocation, correct?
They are not provocation, but if in fact, we're going to ask the court to make this as a matter of law, but there was no provocation because what he's telling you is incorrect. There are his witnesses that are going to be testifying today that say that when Mr. Reeves first came back, what happened was Mr. Oulson looked over at Mr. Reeves and he says, "You turned me in, huh?" He was the first one to initiate that conversation, not Mr. Reeves. And so his own witnesses that are going to testify today, I'm prepared for them. They're going to say that. And so we can't get into this issue of, hey, listen, was it appropriate for Mr. Reeves to engage in that conversation? Because that's exactly what the court here is saying. It's irrelevant if they had 20 conversations in that process. It's totally irrelevant because it does not mean that he acted with any ill will or any hatred or anything of that sort. It has absolutely no relevancy in this particular case, and even more importantly, it's a 403 and highly dangerous.
All right, so you...
May I just a moment with counsel?
Yes, just let me clarify. So let's say, based on this case, I don't give the instruction. Are you indicating that Mr. Martin can't have his witnesses testify as to what happened?
Oh, no. They can testify as to what happened, but he can't get up here and tell this jury that there is some reason for them to decide one way or the other because of that conversation, because that's what Gibbs is saying. We can't do that because there's a reason for the provocation instruction in this particular justifiable use of deadly force. But you can't go beyond that provocation and now start thinking that, well, any word that was said between these two gentlemen somehow has some relevance and some significance. In this case, it does not. And this case is directly on point. It's cited in the jury instruction. I would ask the court to follow it because otherwise, it is, you saw what they did in Gibbs. It was reversed. And so we can't have that here. We've spent way too much time.
Thank you for that reminder. I'm well aware of how much time we've spent. So, again, you keep saying that these activities are completely irrelevant. How do you answer Mr. Martin's argument that that would leave kind of a vacuum?
Judge, the witnesses are going to testify about what happened. What I am concerned about is not that the witnesses are going to testify about what happened. What I am concerned is that in opening statements today, they're going to make this argument that somehow, and you watch and see, if the court denies me, they're going to get up there and they're going to say, Mr. Reeves should have never engaged Mr. Oulson, which is exactly what this court is saying you can't do, because that's the issue of provocation. You can call it provocation, you can call it rekindle, you can call hostility, you can call it whatever you want to call it. It's still provocation. And we can't have that in this particular case. Now, are the witnesses going to be able to say that, hey, listen, when Mr. Reeves came back in, Mr. Oulson, made that statement, or what if they even don't say that? Let's assume that, they don't have that. Mr. Reeves came back and said, oh, I see that you put your phone away. That's perfectly fine. I'm not going to object to that because those are facts, as to what happened there. The danger here is how they use that. How they use that to this jury, because they know that it has absolutely no issue with reference to this case.
The facts, as Mr. Escobar stated them, are almost exactly true. The defendant was the one, based on his own statement. I mean, you're going to hear from witnesses, but the defendant's own statement was, when he came back from the manager, he initiated a contact with Chad Oulson. We are not going to be arguing anything different than the jury instruction. We're not going to try to put any facts out there or apply the facts to the law, as the law does not exist. We're not doing that. But the facts are certainly relevant, and I think that the court's obviously indicating that it is. But we are not going to be arguing this case any way different than what the law allows.
Give me an example. Do you have an example?
When Mr. Reeves came back from the manager, as he's walking down the row, or when he sits down, or immediately thereafter, he initiates a conversation with Chad Oulson. At that time, he says to him words to the effect of, "I see you put your phone away. I went to the manager for no reason." It's at that point in time that Chad Oulson turns around in his seat. I mean, that's basically exactly what I'm going to say.
Okay.
Judge, if that's all he says, then I'm not concerned about it. But I am concerned if he says anything about fault in what kindled this.
All right.
That'll probably be more closing than opening. Yeah.
Right.
And we are allowed to draw whatever inferences the facts.
All right, so we're clear on openings, we can get started. I'll look a little closer at this case, and I'll make my final decision as to the jury instruction when we're at a break or something, when we're discussing other matters. Anything else that we need to address this morning?
Yes, Your Honor, unfortunately. I was told this morning that the exhibits that Mr. Martin had told me were going to be played in opening statements. They're not going to play those exhibits now. They're going to be playing some ABI exhibits. And if the court recalls the conversation that we had Friday concerning these videos, some of them have blue screens or black screens that show up when the video is not recording. And we talked about some videos that actually have the last frame that is recorded, and it stays in that last frame while it's not recorded. And Mr. Martin, I can get the transcript, Mr. Martin himself agreed that that particular type of video was certainly a video that would suggest to the court something that the evidence isn't, meaning that that frame stays, and the jury gets the impression that that's the recording, and when it's not, that it's misleading. He said that Friday. He agreed with that Friday. Today he wants to introduce that, and so we would object. We think it's misleading. There is absolutely no reason that we need to introduce anything that's misleading to this jury.
Mr. Martin?
In this particular case, there's the first exhibit is the native video that was downloaded by the IT at Cobb, given to Fred Myers, and given to the sheriff's office. Later on, we got the hard drive. Our experts determined that what was on this USB hard drive that you stick in the computer and the hard drive were in fact the same. Now, what was downloaded on the 15th is known as a recorded video. It is the native video right out of the DVR. There is no blue screens. It runs continually, and it's the native video. From the hard drive, we exported not only the recorded video, which is just the recorded video it goes from back to back. Then you have a real-time video where the DVR software itself actually inserted the blue screens to show where there was no recording. I haven't even received all of the new exhibits from the defense today. I received some over the weekend after reviewing what their expert has redone, which I haven't been able to talk to him about. No, I got them. I watched them. Once I watched them and discussed it with my expert, it's important for the jury to know what the native raw data is. And that's the reason today, at the beginning, I will play the native raw data off that flash drive. I already have it preloaded on the whiteboard. Right after that, I will play the native raw data in which the blue screens were inserted on all three cameras. So they'll see the native raw data real time, that it's just straight, and then immediately after will be the blue screen. And we will use the blue screens with our witnesses. The first exhibit will be used either with my witness or with, in my cross of their witness, but we are going to be playing it, and I think because of what Mr. Escobar handed me over the weekend, I have no choice but to let the jury see what is an absolute, no enhancement, no nothing, no one's manipulated it at all, because the defense exhibits that I have been manipulated to the point that they have to see the raw data. And that's why it's being put on. I'm not going to argue that this timely. It's just, we're going to play one after another. And it's almost like any type of enhancer. You put in the original first, then you put in the blue screens. That's what we're doing, back to back.
Judge, if I may, because I want to clear this record, I'm going to show you what was given to me by the prosecution, which is the raw data. They went through great lengths with Emily to put the raw data and use it with the GeoVision. Where's the second one? We've got two of these. Two Transcend thumb drives. They went through a great deal of work with Emily in order to get the raw data to play on the GeoVision software, which was the software that was in the DVR at the theater. This is raw data. For him to say now that he has to play this other video because it's raw data is not correct, and it's not true. This is raw data. This is GeoVision. I think that the reason, frankly, now that they're switching horses and they don't want to play this one is because ours is I think, a much clearer portrayal of the actual video. And let me tell you what we did. Ours is very simple. If we had a screen of the video this big, we used nearest neighbor, and we made it this big. That's it. Ours don't even cover the entire screen. You know why? Because there's a mathematical formula that you have. It's got to be a square. If you go beyond a square, you're using interpolation, and we don't want to do that. And so ours, the screen doesn't do anything to our videos. Our videos are what they are, and our experts are going to testify about that. But think about it. We're now introducing a video, which up until this morning, he said he was going to use this. Now he's going to use a video that has the last frame continuing to run, as if someone that's looking at it is going to think, oh, that's what's happening during that period of time, for no reason whatsoever, when he's got the raw video. These are the raw videos with the GeoVision, which they made such a big deal about that they had to get a GeoVision software to make them operate. To be honest with you, you don't need a GeoVision software to operate these things. We looked at it. We didn't want to do what he did, but I think at this point in time, Your Honor, we're creating, in the eyes of the jury, we're creating something that they're seeing that clearly is misleading. And Judge, I'll be more than glad to get the transcript from Friday where he admitted that it was misleading. And here we are, now he wants to introduce it.
Your Honor, it's the raw data, and then what he showed the court very dramatically, what I gave him, then I'm going to play those. So it's not misleading. They're going to see it back to back to back. It's not going to be misleading. It's just like we would do with our experts. You put on the original raw, then you do the enhancements. It's important that they see what the native video is.
All right,
And so it's not misleading.
now Friday we were talking about raw data, now we're talking native. What's the difference here?
I'm sorry, it's just a term, it's the same.
All right,
It's
so
raw.
the one that you intend to show is the same one that Mr. Escobar is showing?
What he's showing, no, I'm not.
No. I mean, look, this is
I plan to, that'll be the second video. The first video, which has already been stipulated to previously, back 5 years ago, that whatever, I'm not going to repeat the stipulation, all right. It's already been stipulated. It's coming in. I mean, there's no argument it's not. He's arguing, well, it's a 403, and I said it's this. I go, yeah, I'm not going to use it with the witnesses. We'll use the other ones, but they need to know what the raw looks like. So I'm going to play that, and then 3 more. right at the beginning before any witness. It's just, the unrecorded's not there.
But for time frame, it shows on there that there's a gap. So for example, it would go up to 1 minute, and then it'll start at 1:03. So if you looked at the time, you know there's a 3-minute gap. Just the other video inserts a blue screen. This original video just shows 3 minutes went by. No one in here is going to be arguing anything at all to mislead the jury that it's one continuous set of events. So that's the most important thing.
Judge, take a look at that video, and you tell me whether you can tell that there's 3 minutes that go between one screen and another. You won't be able to. Neither will I, and neither will that jury.
If you want us to, we will argue it. We're not going to mislead the jury.
Then why do we need to show that one? Where did that come from?
It is direct response to the manipulated videos that I was provided by the defense that they're going to put on. They have to know what the video looks like, whether it's a fair and accurate representation of what the DVR produced as opposed to the manipulated DVDs that the defense is going to put on in this case. It's paramount that they see this particular video. They have to. They're going to determine whether or not one set of videos or another is in fact. If I'm precluded from putting on the native raw to show the extreme difference between the other one, then that would be wrong.
All right, and we've talked about that.
Yeah.
I insisted that they get to see the original, raw, native, naked, whatever you want to call it, so they can make the decision by themselves. They can be the fact finders that they need to be, and they can give each expert's witness testimony the weight that they think it deserves based on the differences in the videos. If you know, and I've said all along since Friday, you know, I haven't seen these videos in many years, and I don't know if we've got new versions, but you know, all this arguing that we've been doing about these videos, I'm wondering, is there any difference that the jury's going to see? But
Yes, Judge, and I will tell
waits
you,
to be seen.
I will tell you what we signed. You have the signed stipulation on exhibits 2 and 3. Is it here? Let me show you what we agreed to this weekend. We spent an enormous amount of time agreeing to on those transcend thumb drives. Can I approach?
Yes?
It hasn't been signed right now, but we've signed.
All right.
Mr. Reeves has signed it.
I know.
Yeah. And so we spent, now, Judge, if you want to, let me have the transcends. You can put it on. I want to explain this to you because it's so important. They went through great lengths with Emma to get the raw video with the GeoVision software. That GeoVision software actually puts blue screens when it's not recorded. So let's think about that. The GeoVision software that was in the DVRs puts the blue screens when it's not recorded. But he wants to introduce raw data that doesn't do that. Does that make any sense? We went through great lengths, and I agreed. I said, I looked at him, I said, yeah, we'll sign off on it. You know, you can, this morning, he says, we're canceling that. Now we're putting in some AVI that doesn't have those blue screens in between. That is misleading, especially since he agreed on Friday that it was misleading. Here we are arguing about something that, Your Honor, he agreed to on Friday that it was misleading. We can't mislead this jury. And by the way, he says that ours is manipulated. Can you please tell us what we did in manipulating? I can tell you, ours is
It's okay.
nearest neighbor.
I know, nearest neighbor, and I know. We're not going to go into that again. And theirs is, remind me.
It's by cubic.
By
feet,
cubic,
but the
thank you.
bottom line is none of that. And yes, I'm still playing what I told him I was going to play. We're just playing the first one, which is the stipulation that we signed many years ago. We all agreed what it was, and I played it right from the beginning of last year.
Did you all stipulate to this years ago?
As far as the one AWS, yes.
Whatever one, the
Yes,
one, the
it was
controversial
stipulated
one
years-
today.
It was stipulated
Your Honor,
years ago.
what we stipulated to was that those were in fact authentic videos. Not that playing it before this jury was going to be appropriate, because I can tell you that we weren't doing that. All of ours have black screens. In between every area, it has black screens, and it actually has a counter on the black screen that you can really read, and you can see, okay, the next screen is coming up in a minute, or the next screen that's being recorded is coming up in 30 seconds, so that the person that's looking at it can say, okay, it's not recording right now, but in 30 seconds we're going to get some more recording, and bingo, the next recording comes up, and then the black screen comes up again. Okay, next recording is going to be in a minute and 30 seconds, and a minute and 30 seconds, bingo, it comes up. It's a very easy process for jurors to understand, and we're not confusing them. And so, I would object, Your Honor. What I would ask the court, if for some reason the court rules against us, that particular video that is being played in opening be entered into court's evidence, so that we can have it preserved for any future need.
Tell me again, why do you need this different one?
The very first one that we got 2 days afterwards, because that is the raw data that neither expert has touched. The jury needs to see that so that they can, like you said, determine which one they're going to accept. It is extremely different from the experts, and so they're going to have to make the decision. And like I said, we are going to play the other one right behind it. They're not going to be misled. They're going to know that there's gaps. So
All right.
I want to play it
All right,
from the start.
I'm going to allow it. If it's the raw, if it is what it is, then that's what they're going to get to see. Obviously, the next one's going to show the time gaps with what, yours is blue, and I'm going to allow it, and we'll enter it as a court exhibit.
As a court exhibit?
Yeah.
I'd offer it as state's exhibit number 1.
Well, I mean,
We're not using it in opening.
If you've agreed to have it in, then it's going to be in as part of the record. I just want to make sure that that thumb drive stays here with the clerk, because if there's an issue later on, you need to have that preserved as to what was showed.
I have it. I'm going to hand it to the clerk. It's already loaded on the whiteboard, then I'll play it. But it will be offered, admitted. I have it here. It will be in the court file.
so who's gonna, what witness is gonna?
It's solely based on the stipulation. You're going to read
Okay.
that stipulation, then I'm going to play 3 more. So I'll offer it into evidence based on the previous stipulation. It'll be marked, entered. I'll play it on the whiteboard, and then I'll play the next 3, which will be State's Exhibits number 2.
All right, so, how's this gonna work? Are you gonna, am I gonna read a stipulation during opening?
We're not playing a video in open.
Okay,
That's why
okay. I thought that's what this was all about
I
right
think Mr.
now.
Escobar thought that we were gonna play the video in opening. We're not playing the video in opening. It would be at the beginning of the state's case in chief.
Okay,
It'll be
okay, that's why I
for-
couldn't understand, how are you gonna enter it during openings if, you know,
No.
you don't have a witness?
No, it'll be
Okay.
before any witnesses. I'm going to play 4 videos. Based on the stipulations, then we'll put on our first witness.
Okay.
I don't need a witness
To play them, that's correct, but, and you either have to have a stipulation or a witness to
Yes.
enter it,
So
so,
we have the stipulations for those
okay.
videos.
So, just for housekeeping matters, before you play the video, I assume I'm gonna be reading a stipulation.
As far as the first one, we can go back to the one we signed years later.
All right,
We have that. In fact, I'll work on something and with the highlighter, so because it covers so much, then I'll review it with Mr. Escobar, and then we'll provide it to the court. But I was just going to enter pursuant to previous stipulations, so we didn't have to refer to anything.
Okay,
which we all know what it is and occurred.
all right. Anything else we need to address before we get the jury in?
Just signing these orders real quick,
Okay,
and then if you'll, may I approach or maybe,
you can come up.
thank you.
These originals are going in the court
Well,
file?
if you'll
You need-
return them to
okay.
me, I'll make sure everyone gets a copy.
All right.
Not for a copy, if you have to want a copy. Thank you, Your Honor.
All right, so do we have all the jurors? Awesome. Are we ready?
They're in the original.
Oh, fantastic, good job. All right, are we ready to bring them out?
Yes, Your Honor, we are.
Excellent. All right, so they'll be sworn. I've got a little bit of instruction for them, and then you'll begin openings.